5. Contractor mini review for contracts and sales in Module 3 titled Consideration on page 31, and we have until page, 59 or something to go. Courts will enforce a promise as a contract only if it is supported by consideration or a substitute for consideration. Elements of consideration. Basically, 2 elements are necessary to constitute consideration. 1 is a bargain for exchange between the parties, and 2 is legal value, meaning that which is bargained for must be considered of legal value, or as it is traditionally stated, it must constitute a benefit to the promissory or a detriment to the promisee. Bargain for exchange. This element of consideration requires the promise induce the detriment and the detriment induce the promise. There is no bargain involved, meaning no consideration when one party gives a gift to another. Acts of forbearance by promisee must be of benefit to promisor. An act or forbearance by the promisee or a promise to act or forbear is sufficient consideration to form a contract if it benefits the promisor. The benefit, however, need not be economic. For example, the gratification of influencing the mind of another is sufficient. Past or moral consideration. A promise given in exchange for something already done does not satisfy the bargain requirement. Exceptions. Where a past obligation is unenforceable because of a technical defense, for example, the statute of limitations, that obligation will be enforceable if new promise is made in writing or is partially performed. Also, under the modern trend, if the past act benefited the promisor and was performed by the promisee at the promisor's request or in response to an emergency, a subsequent promise to pay for that act will be enforceable. Legal value element, adequacy of consideration. In general, courts do not inquire into the adequacy or fairness of consideration. However, if something is entirely devoid of value, token consideration, it is insufficient. Sham consideration, insignificant sum recited in the contract is also insufficient if not paid. But note that if there is a possibility of value in the thing bargained for, consideration will be found even if the value never comes into existence. Legal benefit and legal detriment. Legal detriment results if the promisee does something they are not legally obligated to do or refrains from doing something that they have a legal right to do. A legal benefit is the reverse. It is a forbearance or performance of an act that the promisor was not legally entitled to do or to demand or expect. Pre-existing legal duty, not consideration. Traditionally, performing or promising to perform an existing legal duty is insufficient consideration. Exceptions. The pre-existing legal duty rule is riddled with exceptions. There is consideration if new or different considerations promised. The promise is to ratify a voidable obligation, for example, a promise to ratify a minor's contract after reaching majority, or the promise to go through with the contract despite the other party's fraud. And the pre-existing duty is owed to a third person other than the promisor. There is an honest dispute as to the duty, or there are unforeseen circumstances sufficient to discharge a party, such as impracticability, or under the modern view, if the modification is fair and equitable in view of the circumstances not anticipated when the contract was made. Also, a good faith agreement modifying a contract subject to the UCC needs no consideration to be binding. Modification of contracts. Under general contract law, a contract can't be modified unless the contract is supported by new consideration. The modern view, however, permits modification without consideration if the modification is due to circumstances that were unanticipated by the parties when the contract was made. And 2, it is fair and equitable. Under the UCC, consideration isn't necessary to modify. All the parties need are good faith promises of new and different terms. Discharge of debts. A debt can be discharged through an accord and satisfaction. See discussion in Module 6. In general, an accord must be supported by consideration, even if the consideration is of lesser value than the originally bargained for consideration. In the prior contract, it is sufficient if the new consideration is of a different type, or if the claim is to be paid for to a third party. In addition, a debtor's offer to make a partial payment on an existing debt will suffice for an accord and satisfaction if there is some bona fide dispute as to the underlying claim, or there's otherwise some alteration, even if slight, in the debtor's consideration. Forbearance to sue. A promise to refrain from suing on a claim constitutes consideration if the claim is valid or the claimant in good faith believed the claim was valid. 3.2, mutual and illusory promises requirement of mutuality. Consideration must exist on both sides of a contract, although the benefit of the bargain generally need not flow to all parties. If only one party is bound to perform, the promise is illusory and will not be enforced. Courts often supply implied promises. For example, a party must use their best efforts to infer mutuality. Examples. The following are common examples of contracts that satisfy the mutuality requirement. Requirements in output contracts, conditional premises, unless the condition is entirely within the promisor's control. Contracts where the party has a right to cancel if that right is somehow restricted. For example, a party must give 60 days notice. Exclusivity agreements, for example, exclusive marketing agreements, because the court will find an implied promise to use best efforts. Voidable promises, for example, one made by an infant. Unilateral and option contracts, and gratuitous suretyship promises made before or at the same time the consideration flows to the principal debtor. Right to choose alternate courses. A promise to choose one of several alternate means of performance is illusory unless every alternative involves legal detriment to the promisor. The promise will not be found illusory if 1, at least one alternative involves legal detriment, and the power to choose rests of the promisee or a third party, or 2, valuable alternative, that is, 1 involving legal detriment is actually selected. Promissory estoppel or detrimental reliance. Consideration is not necessary if the facts indicate that the promisor should be estopped from performing. A promise is enforceable if necessary to prevent injustice if the promisor should reasonably expect to induce action or forbearance, and such action or forbearance in fact induced. So that's promissory estoppel and detrimental reliance. That's a rather short. If the facts indicate that the promisor should be stopped from not performing a promise is enforced. If necessary to prevent injustice, even when there is no consideration, the promisor should reasonably expect to induce action for forbearance, and such action or forbearance, in fact, was induced. The elements for promissory estoppel are present. Some jurisdictions will award expectation damages, that is what was promised under the contract, but the second restatement provides that the remedy may be limited as justice requires. Thus, a court following the second restatement might award reliance damages, that is, whatever the promisee spent in reliance on the promisee, which usually is something less than expectation damages, but theoretically can exceed them. Now we're in Module 4, requirement that no defenses exist. Even if an agreement is supported by valuable consideration or a recognized substitute, contract rights may still be unenforceable because there is a defect in capacity, making the obligations voidable by one of the parties because there is a defense to formation of the contract or because a defense to enforcement of certain terms exists. That's a snack tree. I'm mad about it, actually. He made himself healthy. Defense is based on lack of capacity. Legal incapacity to contract. Contracts of infants, minors, Infants in most jurisdictions, anyone under the age of 18 generally lack capacity to enter into a contract binding on themselves. The contractual promises of an adult made to an infant are binding on the adult. Disaffirmance. An infant minor may choose to disaffirm a contract anytime before or shortly after reaching the age of majority. A contract must be disaffirmed as a whole. It can't be affirmed in part and disaffirmed in part. If an infant chooses to disaffirm, they must return anything they had received under the contract that still remains at the time of disaffirmance. However, there is no obligation to return any part of the consideration that has been squandered, wasted, or negligently destroyed. Exceptions. States have created a few statutory exceptions for student loans, insurance contracts, and agreements not to reveal an employer's proprietary information. Necessaries. Necessaries are items necessary for subsistence, health, or education, including food, shelter, clothing, or medical care. A minor may disaffirm a contract for necessaries, but will be liable in restitution for the value of the benefits received. Affirmance upon attaining majority. A minor may affirm, that is, choose to be bound by the contract in whole upon reaching majority. A minor affirms either expressly or by conduct, such as by failing to disaffirm the contract within a reasonable manner or time after reaching majority. Mental incapacity. One whose mental capacity is so deficient that they are incapable of understanding the nature and significance of a contract may disaffirm when lucid or by a later appointed legal representative. They may likewise affirm during a lucid interval or upon complete recovery, even without formal restoration by judicial action. In other words, a contract is voidable. Like minors, mentally incompetent persons are liable in quasi-contract for necessaries. Note that a mentally incompetent person that has no ability to contract once a guardian has been appointed. Any attempted contracts by an incapacitated person who is under a guardianship are void. Intoxicated persons. One who is so intoxicated that they don't understand the nature and significance of their promise may be held to have made only a voidable promise if the other party had reason to know of the intoxication. The intoxicated person may affirm the contract upon recovery. Once again, there may be quasi-contractual recovery for necessaries furnished during the period of incapacity. Duress and undue influence. Contracts induced by duress or undue influence are voidable and may be rescinded as long as they are not affirmed. The common type of duress occurs when a party's assent is procured by an improper threat. For example, sign the contract or I'll break your legs. Generally, taking advantage of another person's economic needs is not duress, but withholding something someone wants or needs will constitute economic duress. If one, the party, threatens to commit a wrongful act that would seriously threaten the other contracting party's property or finances, and two, there is no adequate means available to prevent the threat and loss. Elements of undue influence are 1, undue susceptibility to pressure by one party, and 2, excessive pressure by the other party. Undue influence concerns often arise when the dominant party is in a confidential or caregiver relationship with the influenced party. Absence of mutual assent. Misunderstanding. Ambiguous contract language. If the contract includes a term with at least 2 possible meanings, the result depends on the party's awareness of the ambiguity. Neither party aware. No contract unless both parties intended the same meaning. Both parties aware. No contract unless both parties intended the same meaning, or one party aware. Binding contract based on what the ignorant party reasonably believes to be the meaning of the ambiguous words. So there are 3 different alternatives when there's an absence of mutual assent, i.e. misunderstanding, and ambiguous contract language. If neither party was aware of the ambiguity, no contract, unless they both intended the same meaning. And if both parties were aware, there's still no contract unless both parties intended the same meaning. And if one party was aware, a binding contract based on what the ignorant party reasonably believes to be the meaning of the ambiguous words. And ambiguity is one area where subjective intent is taken into account. Mutual mistake to existing facts. If both parties entering into a contract are mistaken about existing facts, not future happenings relating to the agreement, the contract may be voidable by the adversely affected party if the mistake concerns a basic assumption on which the contract is made. For example, the parties think they are contracting for the sale of a diamond, but in reality, the stone is a cubic zirconia. The mistake has a material effect on the agreed upon exchange. For example, the cubic zirconia is worth only 1/100th of what the diamond is worth, and the party seeking avoidance not assume the risk of the mistake. So that's mutual mistake as to existing facts. It's avoidable by the adversely affected party when the mistake concerns a mutual assumption on which the contract was made, has a material effect, and the party seeking avoidance not assume the risk of the mistake. Not a defense if party bore the risk. Mutual mistake is not a defense of the party asserting mistake as a defense bore the risk that the assumption was mistaken. This commonly occurs when one party is in a position to better know the risks than the other party, for example, contractor versus homeowner, or where the parties knew that their assumption was doubtful. That is, when the parties are consciously aware of their ignorance. Mistaken value generally not a defense. If the parties to a contract made assumption as to the value of a subject matter, mistakes of those assumptions will generally not be remedied, even though the value of the subject matter is generally a basic assumption, and the mistake creates a material imbalance because both parties usually assume that the risk of their assumption as to the value is wrong. Compare unilateral mistake. If only one of the parties is mistaken about the facts relating to the agreement, mistake will not prevent formation of a contract. But if the mistaken party knew or had reason to know the mistake made by the other party, the contract is voidable by the mistaken party. As with the mutual mistake, the mistake must have a material effect on the agreed upon exchange, and the mistaken party must not have borne the risk of mistake. So that is a unilateral mistake. Will not prevent the formation of a contract, but if one person knew of the other's mistake, can be voidable by the mistaken party if the risk was not borne by that party. Mistake by the intermediary transmission, in parentheses, where there is a mistake in the transmission of an offer or acceptance by an intermediary, the prevailing view is the message as transmitted is operative unless the other party knew or should have known of the mistake. Misrepresentation, fraudulent misrepresentation, fraud in the inducement. If a party induces another to enter into a contract by using fraudulent misrepresentation, that is, by asserting information they know is untrue, the contract is voidable by the innocent party if they justifiably relied on the fraudulent misrepresentation. This is fraud in the inducement. It doesn't say anything in there about intent. It just is knowledge that the information was untrue. Material misrepresentation. I think intent belongs in that paragraph, but let's just see if maybe I'm wrong. I think it does because the fraud is in the title and fraud requires intent. So let's just say if a party intentionally induces another to enter into a contract by using fraudulent misrepresentation, that is asserting information they know to be untrue, with the intent that that innocent party rely on the fraudulent misrepresentation, and that party actually did so rely. Material misrepresentation, whether or not a misrepresentation is fraudulent, the contract is voidable if the innocent party, if the innocent party justifiably relied on misrepresentation, and if the misrepresentation is material. A misrepresentation is material if it would induce a reasonable person to agree, or the maker knows that for some special reason is likely to induce a particular person to agree, even if the reasonable person would not. So remember that part. Next page, 48. 4, justified reliance. A party is not entitled to relief if the reliance was unreasonable under the circumstances. However, just because the misrepresentation could have been revealed by the exercise of reasonable care does not mean that reliance was unjustified. Failure to read a contract or use care in reading it does not necessarily preclude a party from avoiding a contract for misrepresentation. Innocent party may rescind agreement and recover damages. Note that the innocent party doesn't have to wait until they're sued on the contract, but may take affirmative action equity to rescind the agreement. In addition, they may pursue all remedies available for breach of contract. Absence of consideration. If the promises exchange at the formation stage lack the elements of bargain or legal detriment, no contract exists. In this situation, one of the promises is always illusory. 4.4, public party defense is illegality. If the consideration or subject matter of a contract is illegal, for example, a contract to commit a murder, the contract is void. Exceptions. The plaintiff is unaware of the illegality while the defendant knows of the illegality. 2, the parties are not in pari delicto, that is, one party is not as culpable as the other. Or 3, the illegality is the failure to obtain a license when the license is revenue-raising purposes rather than for protection of the public. If the only purpose behind the contract is illegal, the contract is voidable by the party who was 1, unaware of the purpose, or 2, aware but not facilitate the purpose, and the purpose does not involve serious moral turpitude. Unconscionability. The concept of unconscionability allows the court to modify or refuse to enforce an entire contract or a provision of it to avoid unfair terms, usually due to some unfairness in the bargaining process, that is, procedural unconscionability. Unfair price alone is not a ground for unconscionability. Common instances of procedural unconscionability: inconspicuous risk-shifting provisions. Standardized printed form contracts often contain a material provision that seeks to shift a risk normally borne by one party to the other. Typically, these clauses are found in the fine print, boilerplate, and printed form contracts. Courts have invalidated these provisions because they are inconspicuous or incomprehensible to the average person, even if brought to their actual attention. Contracts of adhesion, take it or leave it. Courts will deem a clause unconscionable and unenforceable if the signer is unable to procure necessary goods, such as an automobile, from any seller without agreeing to similar provision. Exculpatory clauses. An exculpatory clause releasing a contracting party from liability for their own intentional wrongful acts is usually found to be unconscionable because such a clause is against public policy in most states. Exculpatory clauses for negligent acts may be found to be unconscionable if the clauses are inconspicuous, as discussed above, but they commonly are upheld if they are in contracts for activities that are known to be hazardous. For example, a contract releasing a ski hill operator for liability for negligence often will be upheld. Limitations on liabilities. A contractual defense limiting liability for damages to property generally will not be found unconscionable unless it is inconspicuous. But a contract that limits a party to a certain remedy and that remedy fails of its essential purpose. For example, the contract limits remedies to repair and the item cannot be repaired. The limitation may be found unconscionable and courts will ignore it. Timing. Unconscionability is determined by the circumstances as they existed at the time the contract was formed. Effect if court finds unconscionable clause. If the court finds as a matter of law that a contract or any clause of the contract was unconscionable when made, the court may refuse to enforce the contract, enforce the remainder of the contract without the unconscionable clause, or limit the application of any clause so as to avoid the unconscionable result. That's interesting. It sounds like reformation without saying it. Or rescission. But I digress. We're going into statute of frauds on page 47. If this section is 10 pages long, and even if it's not, I'm probably going to skip it because it's just so fundamental. My legs is the mnemonic that explains it. So the M is for marriages, promises in consideration of marriage. There's promises. The Y stands for years, performance not within 1 year from the date of the contract. That cannot be performed within 1 year of the date of the contract. Legs, L, land, interest in land. Lease, this I'm going to read, leases for more than 1 year, easements of more than 1 year, mortgages, and most other security liens, fixtures. What about fixtures? Minerals or the like, or structures, if they are to be severed by the buyer, and items that do not create an interest in land, contracts to build or building for a seller do not create an interest in land. Effective performance of contracts, and executor or administrator promises personally to pay estate debts. Okay, so that's the E, estate, executor. G is goods priced at $500 or more. And the S stands for suretyship, promises to pay the debt of another, suretyship promise. So that ends the, as much as I'm going to read it, on statute of frauds. I like to read the definition of statute of frauds, just so I have it available. Jesus, this one really shows his dinosaur traits. He's just like, are you looking? Effects of non-compliance with the statute. Non-compliance with the statute of frauds renders the contract unenforceable at the option of the party to be charged. In other words, the party being sued may raise the lack of sufficient writing as an affirmative defense. If the statute isn't raised as a defense, it is waived. When contract is removed from the statute of frauds. Contract modification. Everything okay over there? Oh, you're not going to let him play with that? A written contract can be modified orally, but the modification must be in writing if the contract as modified falls within the statute of frauds. So for a sale of goods contract, if the contract as modified is for $500 or more, there must be evidence in writing. If the contract as modified is less than $500, no writing is necessary. Common law provisions prohibiting oral modifications not effective. A common law rule is that even if a written contract expressly provides that it may be modified only by a writing, the parties can orally modify the contract. Whereas the UCC, no modification clause is effective. Under the UCC, if a contract explicitly provides that it may not be modified or rescinded except by a signed writing, that provision is given effect. If the contract is between the merchant and non-merchant, however, this provision requires the non-merchant's separate signature. I recall a good faith exception, but who am I? Waiver. If the parties attempt to modify or orally modify a contract that requires written modification, either because of a contract clause or the statute of frauds, it is technically ineffective as a modification, but can operate as a waiver. A waiver can be found whenever the other party has changed position in reliance on the oral modification. However, if a party makes a waiver affecting an executory but not performed portion of the contract, may retract the waiver if they notify the other party that strict performance of the waived terms is required. The waiver may not be retracted if the other party detrimentally relied on it. Performance. Land sale contracts. If a seller conveys property to a buyer, that is, they fully perform, the seller can enforce the buyer's oral promise to pay. Likewise, the buyer may seek to specifically enforce an oral land sale contract under the doctrine of par performance. Par performance that unequivocally indicates that the parties have contracted for the sale of land takes the contract out of the statute of frauds. Most jurisdictions require at least two of the following: payment in whole or in part, possession, and or valuable improvements. Specific performance only. A purchaser of an interest in land may enforce an oral contract in this manner only in equity, meaning they may sue only for specific performance, not damages. Services contracts, full performance required. As noted above, the oral contract that cannot be completed within 1 year has been fully performed by one party is enforceable. Sale of good contracts. Paid performance takes a sale of goods contract out of the statute of frauds when 1, the goods have been specially manufactured, or 2, the goods have been either paid for or accepted. If the sales contract is only partially paid for or accepted, the contract is enforceable only to the extent of the partial payment or acceptance. On page 54 now, almost there. If goods are either received and accepted or paid for, the contract is enforceable. However, the contract is not enforceable beyond the quantity of goods accepted and paid for. Thus, if only some of the goods called for in the oral contract are accepted or paid for, the contract is only partially enforceable. It is indivisible. If an indivisible item is partially paid for, most courts hold that the statute of frauds is satisfied for the whole item. When writing not required, there are 3 situations in which contracts are enforceable without a writing described above. Specially manufactured goods. If goods are to be specially manufactured for the buyer and are not suitable for sale to others by the seller in the ordinary course of their business, the contract is enforceable if the seller has, under circumstances that reasonably indicate that the goods are for the buyer, made a substantial beginning in their manufacture, or commitments for their purchase before notice of repudiation is received. So that's within the specially manufactured goods section. In the admissions and pleadings or court section, we're reading, if a party against whom enforcement is sought admits in pleading, testimony, or otherwise in court that the contract for sale is made, the contract is enforceable without a writing, but in such a case, the contract is not enforced beyond the quantity of the goods admitted. Merchants' confirmatory memo rule. In contracts between merchants, if one party within a reasonable time after an oral agreement has been made sends to the other party a written confirmation to the understanding that is sufficient under the statute of frauds to bind the sender, it will also bind the recipient. If they have reason to know of the confirmation's contents, they do not object to it in writing within 10 days of receipt. Equitable and promissory estoppel. All right, so Estoppel may be applied if it would be inequitable to allow the statute to defeat a meritorious claim. Examples include situations where the defendant falsely and intentionally tells the plaintiff that the contract is not within the statute or induces the plaintiff to change position in reliance on an oral agreement. Judicial admission. If a party admits in pleadings or testimony that there is an agreement, it's treated the same as though a party signed a writing. Writing requirement. The statute of frauds doesn't require a formal written contract. Among other things, the writing can be a receipt, a letter, a check with details on the memo line, or a written offer that was accepted orally. The statute requires only one or more writings that, 1, reasonably identify the subject matter of the contract, 2, indicate the contract has been made between the parties, and 3, state with reasonable certainty the essential terms. Electronic record satisfies the writing. If a law requires a record to be in writing, electronic record such as an email satisfies the law. Essential and material terms. There is no definitive list of essential terms. What is essential depends on the agreement, its context, and the subsequent conduct of the parties, including the dispute that has arisen. There must be enough in the writing to enable a court to enforce the contract. If an essential term is contained in the writing, evidence is admissible to explain the particulars, but evidence will not be admitted to add a missing term. Examples of essential terms include identity of the parties, description of the subject matter, and the terms necessary to make the contract definite. Writings evidencing land sale contracts must contain a description of the land and the price, and those for employment contracts must state the length of employment. For the sale of goods, the UCC requires only some signed writing indicating the contract has been made and specifying the quantity term. Writings evidencing land sale contracts must contain a description of the land and the price. Writings for employment contracts must state the length of employment. Writings evidencing sales of goods contracts must indicate the contract has been made and specify the term. Signature requirement. The signature requirement is liberally construed by most courts. The signature is any mark or symbol made with the intention to authenticate the writing as that of the signer. It need not be handwritten. It can be printed or typed. Under the UCC, the party's initials or letterhead may also be sufficient, and electronic signature is also sufficient. And remedies. Remedies, if contract is within statute, if a contract violates the statute of frauds, in almost all cases, the party the reasonable value of the services for part performance rendered, or the restitution of any other benefit that has been conferred. See Module 8 for more. And that's the end of Module 4.